Hey. A pleasant and good afternoon, and welcome to the University of the Philippines College of Law, where we will hear a timely discussion from experts on human rights and video conferencing in courts. My name is Babel Perez from the Institute of Judicial Administration of the UP Law Center, one of the training arms of the UP College of Law. I will be your MC for this afternoon. To formally welcome the over 400 participants that we have in this forum, we have with us first, and please give a round of applause to the beloved Dean of the UP College of Law, who likewise teaches constitutional law, Dean Edgardo Carlo Lasam Vistan II.
Thank you. Justice Mariano del Castillo, Acting Chancellor of the Philippine Judicial Academy. Court Administrator Raul B. Villanueva. And Dean Jose Manuel I, Diokno, who will be our reactors this afternoon. Members of the faculty, of course, former Judge Raul Pangalangan of the International Criminal Court, Associate Dean Sol Lumba, and the other members of the faculty here of the College of Law present in person and virtually. Our other guests, members of the judiciary who are attending this event in person also and virtually. And of course, our guest of honor and speaker, Deputy Judge Aniel Pahladsingh of the District Court of Rotterdam, the Netherlands. Good afternoon to all of you, and welcome to this talk on human rights and video conferencing in courts. We are indeed privileged to have with us this afternoon Deputy Judge Aniel Pahladsingh of the District Court of Rotterdam, the Netherlands, who will be talking about video conferencing in adjudicative proceedings and its human rights implications as experienced in the European Union. This unique learning opportunity was made possible by Judge Aniel's generous offer made a few months ago to lecture before a Philippine audience while on his current visit to our country. That offer was communicated through Philippine Ambassador to the Netherlands, Jose Eduardo Malaya, and we readily took Judge Aniel on his offer. Expanding the use of video conferencing for the conduct of hearings in court and other adjudicative proceedings was one of the major adjustments that the justice system in the Philippines adopted at the height of the COVID-19 pandemic. This was an adjustment meant to ensure that cases progress and justice is served amidst widespread government restrictions on movement that, for a time, saw courts and other government offices closing shop and suffering severe disruptions in their operations. It would be stating the obvious to say that necessity dictated the adoption of video conferencing as a means to conduct hearings and other proceedings. As the overall public health situation seems to be improving, considerations beyond necessity can now be appreciated in connection with the use of video conferencing as a modality of affording due process to parties. There are many benefits to the use of video conferencing in adjudicative proceedings, to be sure, but the justice system and the legal profession would do well to spend more time evaluating this nascent instrument of justice from various lenses. This afternoon, our guest speaker, Deputy Judge Aniel, will provide one such lens, that of human rights. On behalf of the University of the Philippines Law Center and its Institute for the Administration of Justice, headed by Professor Emer Banyes, we thank the Supreme Court and the Philippine Judicial Academy in partnering with us for this event. We would also like to thank Ambassador Ed Malaya, Philippine Ambassador to the Netherlands, for linking us to our guest speaker so that he may share with us his knowledge and insights on this occasion. We, of course, express our sincerest gratitude to our guest speaker, Deputy Judge Aniel Pahladsingh, for volunteering and coming up with the idea for this talk, which is a timely one as our justice system gears up for a post-COVID-19 pandemic world. We do hope, as you, Judge Pahladsingh, or Judge Aniel, that this will just be the start of a longer-term and fruitful linkage between you and our institutions. Finally, to our audience, thank you all for joining us this afternoon, and we do hope that you get the most out of this learning opportunity. Thank you very much, and I wish you all a pleasant afternoon.
For the Supreme Court's educational arm, the Philippine Judicial Academy, we are very honored and thankful to have with us no other than PhilJust Acting Chancellor and incumbent Vice Chancellor himself, retired Supreme Court Justice Mariano Cairo del Castillo, served as the Supreme Court's chairperson of the Committee on Human Rights and International Law, and is admired to have retired from both Court of Appeals and the Supreme Court with 0 backlog status in the division cases and 0 pending status as well in the en banc cases. Please let us all give a warm welcome to the Honorable Justice Mariano Cairo del Castillo of the Supreme Court.
Director Emerson S. Bañez of the UP Institute for Administration of Justice, Dean Edgardo Carlo L. Bistan II, Court Administrator Raul B. Villanueva, Dean Jose Manuel I. Diokno, participants present on site and remotely, and of course, our esteemed guest, Deputy Judge Aniel Pahladsingh of the District Court of Rotterdam. Good afternoon to you all. The COVID-19 pandemic has immensely affected the legal profession, just like all other industries and professions. From March 2020 to June 2020, proceedings in the Philippine courts all came to a halt. Hearings were suspended since the country was placed under strict quarantine measures. Eventually, the restrictions eased, but the threat of contracting the virus remains ever present. As a response to this situation, the Philippine Supreme Court issued the guidelines on the conduct of video conferencing on December 9, 2020. While the courts welcomed these guidelines, there were and still are certain instances where face-to-face proceedings are required to safeguard the constitutional rights of litigants, particularly the victims and the accused in criminal cases. With the rise of COVID-19 cases in the Philippines and the introduction of a new Omicron subvariant, video conference hearings may be here to stay. It is now a part of our litigation system, and it will probably be utilized even beyond the pandemic. The question now is, how do our courts use these technological facilities while still observing the constitutional safeguards provided to litigants? How do we protect human rights? Video conference hearings are not entirely new in the Philippines. The Supreme Court has already previously issued guidelines on the utilization of video conferencing to protect the rights of certain litigants. For example, under the rule on examination of a child witness, even the child is a victim or a witness in a criminal case. His or her testimony may be taken via live link television. This is to ensure that the child is shielded in the optimum manner possible from any trauma that he or she may suffer if he or she testifies in the presence of the accused. The rights of the child to present credible testimonies are sufficiently balanced with the rights of the accused to meet his or her witnesses face to face. Another example is the guidelines on the use of video conferencing technology for the remote appearance of testimony of certain persons deprived of liberty in jails and national penitentiaries. High-risk and seriously ill persons deprived of liberty may be allowed to participate in court proceedings via video conferencing. In this way, the safety, security, and health of the judges lawyers, litigants, as well as of the general public are protected. In all, the rights of the accused still must be strictly guaranteed. From these examples, we can see that the use of video conferencing facilities has always been a delicate balancing of the rights of the accused and the rights of other litigants, particularly the victims and vulnerable witnesses. The Supreme Court has always been aware that in issuing these guidelines, all the constitutional rights, the human rights of the people involved in court proceedings are safeguarded. Of course, it would be ideal to apply video conference hearings in different contexts of litigation. Maybe even in public interest cases, like the Maguindanao massacre case. If you can recall, the promulgation of the judgment of the trial court in that case was broadcasted live as a response to the request of the victims' families and the general public to hear the decision firsthand. If we can take it a step further, we could probably conduct the trials of similar public interest cases via video conferencing. Professor Pahladsingh may enlighten us on how European courts use video conference hearings during the pandemic, holding inviolate in every way the rights of the accused and the victims, while addressing the legitimate interest of the general public. I hope our participating judges, lawyers, and academics can have a productive and relevant exchange with Professor Pahladsingh. I hope they can share their experiences about video conference hearings here in the Philippines so we can have a comprehensive picture on how this technological tool can be further utilized to promote judicial transparency and integrity. This webinar is an opportunity to reinvent means to address the needs of the public in times of national emergencies or in paramount instances of safety and security. So please make the most of this golden opportunity. Thank you very much, and once again, a pleasant afternoon to you all.
Thank you very much, Dean Vistan. Thank you very much, Justice Del Castillo. Before we proceed, let me acknowledge distinguished members of the UP College of Law's family who are here present, and they are all human rights advocates. We have ICC Judge Raul C. Pangalangan. We have Professor Leo Batad. We have Dean Solomon Lumba. We also have the chairperson of the Supreme Court's Philippine Judicial Academy's Department of Humanitarian Law and Human Rights, in the person of Professor Theodore Ongte. They are all human rights advocates. Okay, let me give you an overview of what will transpire with this 2-hour activity. We shall first hear from our brilliant speaker on developments on human rights and video conferencing in Europe. Then reactions from 2 esteemed and respected Filipino lawyer role models. An opportunity to compare experiences on the topic too. Should you have questions, those with us physically, please feel free to write your questions and hand your questions to our ushers. Those joining us virtually, please type your questions in the chat box for me to read them later during the open forum. Okay, we have 2 We have 2 reactors. Honorable Court Administrator Raul Bautista Villanueva is the only person I know who worked for all 3 branches of the government. At present, he oversees all courts below the Supreme Court. Well, he has been doing that for several years now, either as OIC or Senior Deputy Court Ad for several years. And he is the chairperson of the Supreme Court's Philippine Judicial Academy's Department on Court Administration and Management. Then we will hear from Dean Jose Manuel I, Diokno, who introduced human rights in the law curriculum of De La Salle University College of Law. He's the incumbent chairperson of the Free Legal Assistance Group, the first, the largest, the only nationwide Philippine organization of human rights lawyers. I call him and Professor Te champion protectors of human rights. Now give me the honor to introduce our esteemed speaker for today. This is the shortest I could do of his CV. the CV of an accomplished gentleman. The Honorable Aniel Pahladsingh is President and founder of the Hague International Research Institute Migration Law, a senior legal advisor at the Dutch Ministry of Social Affairs, and for more than a decade now, Deputy Judge at the District Court of Rotterdam. He studied law at Leiden University, worked at the Immigration and Naturalization Service, Secretary of the Commission on European Union Law Council, coordinating EU lawyer at the Research Department of the Council of State in The Hague, seconded twice, first to the Court of Justice of the European Union in Luxembourg, and later to the Ministry of Foreign Affairs. Then there, he was in charge of asylum, migration, and criminal law files, thus his book, Crimmigration. In 2017, he was appointed deputy member at the Human Rights Committee. His extensive experience and writings earned him the reputation of being an expert in the field of human rights protection. A prolific writer and author with a Surinamese-Dutch background, he has to his credit a long list of works published in at least 38 publications in 2 languages with 138 library holdings. Ladies and gentlemen, by way of gratitude as well, please give a warm welcome to the Honorable Deputy Judge Aniel Pahladsingh.
Well, first of all, many thanks, of course, for this invitation, as it is an honor for me to speak here with you all about an important subject of video conferencing hearings at the court during and after the pandemic. I think it's already said, but the COVID-19 outbreak has affected the world in dramatic fashion and led to emergency measures in most member states aimed to contrast a deadly pandemic with few precedents in modern times. Restrictions on human rights have been put in place and justified as exceptional measures to protect public health. Subsequently, in most countries, ordinary hearings held physically in a courtroom were no longer possible in a specific limited period. The pandemic has had a huge impact on the working life of the courts, and hence on the work of judges, judges' assistants, and other court staff. That is reflected in the wide range of measures that were adopted, such as reduction in the number of court staff, implementation of furlough systems, introduction of alternative ways of working digitally, remotely, working from home and on flexible hours, the performance of tasks from home, deliberation, drafting, e-signing of the judgments. It's essential, while we are still in the grip of the pandemic, that we use the past experiences to learn how we are best able to guarantee access to justice. Therefore, a dialogue between the European Union and the Philippines regarding their experiences on the subject of video conference hearings at the court is important. I will first start with an overview what has been happening in the past period in Europe, and then I will highlight some examples from our Dutch case law, which also reflect some, I would say, interesting examples we can provide from the European Union. Afterwards, I will reflect on the balance between transparency and privacy, and then I will finish with some concluding remarks. The European Court on Human Rights has repeatedly emphasized the importance of a public hearing. A number of factors are relevant in that context. The first element is the area of law. The second element is the legal person involved. Are we talking about normal persons? Are we talking about minors? Are we talking about prisoners? The third element is the type of court. Is it a first instance court? Is it the appellate court? Is it the cassation court? Or is it the constitutional court? The fourth element is a hearing mandatory or optional regarding to the national law provisions. The fifth element is the right to be physically present at a court. The sixth element is the question if a hearing can be held remotely. And the last element is, can the hearing be waived and by whom? As for the digital or remote hearings, the first relevant point is the type of two-way communication that is used. By telephone, some form of video conferencing, or also live streaming. Then the setting. There are significant differences between countries and courts in Europe in terms of who can participate in the digital hearing and from what location. I will give you 3 scenarios. The first scenario. All of the participants attend from home, including the judges. This can provide sometimes an unusual glimpse in householdings, glimpse of kitchens, of bedrooms and study rooms, with sometimes holiday snaps or other rare things which you can see in a household. Then we have the second scenario, the judges in the courtroom, everyone else via video. Then we have the third scenario, the judges and some parties in the courtroom, other parties via video, which we called a hybrid hearing. Now, it's time, I think, to have a close look on the situation in the Netherlands and our case law which we have developed. The doors of the courts in the Netherlands were closed between 16 March of 2020 and they were reopened in the middle of May of 2020, which is the first period of the pandemic. During those 2 months, numerous measures were adopted to ensure that the court's own personnel, participants in the proceedings, but also journalists and the general public could again have access to our courts and courtrooms. Many hearings were postponed because of the temporary closure, and the backlog grew rapidly. The Dutch courts employed various methods to continue administering justice during the crisis. The first was to dispose of cases with a decision in camera, without a hearing, which is only possible if procedural law allows for it. The courts also instituted a second round of writing pleadings in lieu of the public hearing. Some hearings were conducted by telephone or video, or in the form of a hybrid hearing, sometimes in combination with a live streaming of the hearing. In the Netherlands, we also implemented legislation which was temporary. It was for the court to decide whether the hearing will be conducted remotely. The court may consider the wishes of the parties in making that decision, but it's not obligated to do so. However, an important caveat is that the judge can only exercise this power if physical hearings are unable to proceed because of the COVID pandemic crisis. The end of the COVID-19 crisis is hopefully in sight, but that's already an uncertainty we have at this moment. And then the question is, will it soon be possible to have all hearings again physically? But that raises a question of its own. Should we really want that? Remote hearings have some drawbacks, but also many benefits. In my opinion, it would be a good thing if the legislator incorporated the option of holding digital remote hearings in our procedural law. At the same time, the legislator could also stipulate for which areas of law, procedures, and legal persons a digital hearing could be held. The rules would be applied, and who would decide whether a hearing could be conducted digitally and whether the consent of the parties would be required. Like the European Court on Human Rights, the highest courts in the Netherlands have had to decide on issues of procedural law arising from this COVID-19 crisis. I would like to briefly mention a number of judgments here. The first case is one which was heard by the Council of State, which is the highest administrative court in the Netherlands, and was followed by a complaint by the applicant to the European Court on Human Rights. The case was about the applicant called Ibrahim Ba against the Netherlands. The case concerned an applicant whose asylum application in the Netherlands had been rejected. He was placed in immigration detention with a view to his deportation. Mr. Ba invoked Article 5 and 6 of the Convention, protecting the right to liberty and the right to a fair trial, complained that his rights under those provisions had been violated because he had not been heard in person by the regional court. The European Court on Human Rights in Strasbourg found the application manifestly ill-founded and referred to the following circumstances. The practical problems were during the first weeks of the pandemic. The de facto impossibility of hearing the applicant in person was an aspect at that time. The regional court had endeavored to hear the applicant in person or by video conference. The regional court explained in detail why it had been unable to do so. The fact that the applicant was represented by and heard through his lawyer by the court was an important aspect. The importance of the applicant's other applicable fundamental rights, namely the right to have the lawfulness of his detention decided speedily by a court, was achieved. And also the general interest of public health was a reasonable justification to limit his rights. So this is, I would say, a positive judgment from the European Court in relationship to our court decision which was made by a Dutch court. But there are also lessons which we can draw from a number of judgments of the Dutch Supreme Court. An interesting judgment of the Dutch Supreme Court concerned the question of whether a hearing that could not be attended by the public because of the outbreak of the pandemic met the requirements of a public hearing. With reference to the relevant case law of the European Court on Human Rights, the Supreme Court in the Netherlands found that not every restriction of access to the courtroom deprives the hearing of its public character. It is relevant that parties and the press were admitted to the courtroom. This provided sufficient guarantees of scrutiny. The non-admission of the public did not detract from that. Furthermore, the complainant that the judgment was not pronounced in public field because the parties and the press could be present at that time. There have been hybrid hearings in the Netherlands, at which some parties were physically present and others participated through video conferencing. This was due to travel restrictions, but also to people being confined to their home because they were infected or required to go into quarantine. Mandatory quarantine also applied to judges if a person in their household had COVID-19, but it did not prevent them from performing their work. The Supreme Court had to rule on an appeal in a criminal case. At the level of the appellate court, the case was heard by a 3-judge chamber, with 2 of the judges present in the courtroom and the 3rd participating through video conferencing. The Supreme Court ruled that in the view of these exceptional circumstances, the principle that a hearing must be public is complied with, provided the following conditions if they are met. The first element is that no more than 1 judge should participate via video conferencing. The second element is that the judge's absence must be directly linked to the outbreak of the pandemic. The third element is that the 2 other judges must be present in the courtroom. The fourth element is that the judge participating by means of 2-way audiovisual communication may not be charged with leading the examination during the hearing. And the last element is that the judge must be able to form a clear impression of the proceedings in the courtroom, and he must be able to participate unhindered in the communication, and he must be visible and audible for those present in the courtroom. The pandemic prompted a wide range of procedural changes across the countries. While not all countries in Europe foresee the changes being permanent, it is likely that the business of courts across Europe will incorporate more technical solutions going forward, even after the pandemic. A danger is that we will fall back into the default position and return to our former ways once before the pandemic. There are questions, and I think it are questions which I also will ask you. One of the first points that needs to be considered in that context is whether the dominance of print communication over digital communication is still justifiable in 2022. The same applies for the primacy of physical presence over digital presence. What is the future of justice? Is court a service or a place? It's a relevant question posed by Professor Richard Susskind. The right to appear in person before a judge can be of great importance, depending in part on the type of case. But providing a few seats for the press and the general public in a court building somewhere in Europe is old school transparency, which adds little to clarity and controllability to the transparent administration of justice. We therefore need to step up. We should combine the physical hearing with digital services, such as improved digital access and digital filing, drafting and e-signing. The technology for video conferencing must be improved. We should end the use of standard office video conferencing software and invest in one court software, secure and under our control, with which we can better safeguard the fundamental rights which are at stake. Video technology of the near future will close also the gap between a physical hearing and a digital hearing. Then I would like to stipulate the following aspect: transparency and privacy. An interesting aspect of the upscaling of digital technologies in administration of justice is the conflict between the right to a public hearing and respect for private life and the protection of the personal data of judges, witnesses, parties, and others attending a hearing. The case law of Europe's highest courts, under the European Convention and the European Charter of Fundamental Rights, has taught us that there is no absolute ranking of fundamental rights, and that rights must be reviewed in relation to their function in society, weighed against other fundamental rights in accordance with the principle of proportionality, and in the event of conflict, reconciled where possible. But what does that mean in the event of a conflict between the right to a public hearing and privacy in court procedures? I'm not aware of any judgments of the highest European courts on that question. But what does conducting a hearing and pronouncing a judgment in public mean in 2022? The Anglo-American concept of public justice differs greatly from that of many European countries. Since 1955, the US Supreme Court has produced audio recordings of hearings, which are published for the public. Documents of cases heard by the federal courts are in principle also available to the public. That raises the question, what is the European concept? What is the European tradition? Do we have a tradition? The answer is no, we don't have a European tradition in this way. But if we look at the practice of the European Court on Human Rights, on the publication of case documents and of recordings of hearings, it seems to correspond with the vision of the American courts. So it's now up to the member states in Europe to see if we will follow that line. I will now make some concluding remarks regarding to the subject of video conference hearing at the court. First of all, how far is the trend of video conference hearing compatible with fundamental rights? First, will IT help the multi-level approach to the fundamental rights respect that so successfully integrated the case law which we have with our national constitutions? Or will it be a major threat to such balance of powers, at least due to unprecedented concentration of information and possibly of its selection through a single European exchange information tool? Secondly, at what extent will we be dealing with case law in the future? Fundamental rights and the multi-level approach to their protection are neutral. So that's an important element. Of course, the usability and robustness of the technology involved can play a very important role during the hearing itself. Furthermore, there's a lot to be said in favor of in-person advocacy. It's arguably easier to persuade and to articulate a question or an argument directly before a judge, directly before a jury, or directly before witnesses. Despite those challenges, the use of video conference hearings brings great number of benefits. For example, lawyers who are able to appear in court from their chambers or offices can avoid the time that was once wasted by traveling and moving to the court and having to wait around at the court when the case is running for a hearing. Instead, they can continue to work on other matters and then be called to appear when their matter is ready, saving also costs for their clients. As for advocacy skills in the virtual courtroom, no doubt that the national bar associations and educational training centers will provide professional development for lawyers to bolster online advocacy and strategies in instances where oral submissions are interrupted by faulty technology and where cross-examination is to be conducted via video link. Virtual courtrooms are now hosted in different member states through various different platforms, such as Zoom, Microsoft Teams, Cisco WebEx, which are necessary and for the most part relatively accessible and user-friendly. Nevertheless, the accessibility of these platforms presents various security and confidentiality risks, and fundamental rights such as private life and data protection should be ensured. The precondition, in my view, is that the video conference hearing is confidential and information generally have to be kept secret and secured. Yet, there may be little evidence as yet about the security of these platforms to give rise to concerns about that, whether the court and parties can communicate freely and securely. I advise, at least on EU level, to create one virtual courtroom platform specifically made for the legal profession. It's a fundamental feature of the law that the administration of justice is open and accessible for public scrutiny, particularly with respect to matters of public interest. Therefore, it will be important that the courts will ensure that virtual hearings are, in generally, readily accessible to the public. Thank you for your time, and this was my presentation for this moment. Thank you.
Okay, let us hear first from our court administrator. The court administrator Villanueva, please. The virtual floor is yours.
Yes, good afternoon, Mabel. And good afternoon, of course, to our guest lecturer, Deputy Judge Aniel Pahladsingh. Congratulations to that presentation of yours. Of course, I would like to give my shout-outs or greetings first before I proceed with my reaction. First to PILJA Vice Chancellor and of course Acting Chancellor right now, Justice Mariano del Castillo. Likewise, I would like to of course greet our Dean of the UP College of Law. I am of course an alumnus of this prestigious university. Dean, if you do not know, Dean Edgardo Carlo Bistan II. So good afternoon to you. Of course, my greetings as well to my co-reactor, my idol. I usually do not see him, but of course I know him way back already several years ago. Of course, Dean Chel, Diokno. Good afternoon to you, Dean. And of course, Director Emerson Banyas, who extended the invitation to me to serve as a reactor for today's lecture from Deputy Judge Aniel Pahladsingh. My reaction, I have a presentation, a short PowerPoint presentation, Mabel. Can that be shared, or would you like me to share, do the sharing? Mabel? I'll try to follow the 10-minute time given to me. I assure you, but I just would like to find out if I can share, Mabel, so that it will be easier for me to make my reaction. If not, I will just proceed. First, of course, there is no issue, that for more than 2 years, face-to-face hearings prior to the pandemic, face-to-face hearings actually was the set standard insofar as court proceedings are concerned. But during the pandemic and even up to now, video conferencing took the center stage, so to speak, in handling first remote court appearances, and second with respect to making available access to justice. So that's what video conferencing has done, especially during the onslaught of the COVID-19 pandemic, which started in March, as noted by Deputy Judge Pahladsingh in March of 2020. Similar to, I would just like to state that I agree in his written lecture that indeed the COVID-19 outbreak actually challenged long-established legal procedures, and in fact, including the material functioning of our courts and the rule of law itself. As stated and declared by our lecturer. So some of the challenges that we face because of the COVID-19 pandemic, all mentioned, or many of which were mentioned by our guest lecturer. First, of course, practically many of our proceedings, especially during the height of the restrictions imposed by the government, were almost were suspended or almost put to a halt. In fact, for the information of Deputy Judge Pahladsingh, the country right now, up to September of 2022, remains under a state of public health emergency. That's why restrictions can be imposed at any time. We are following a certain alert level system, which help determine what kind of restrictions and what kind of protocols should be put in place or implemented, especially with respect to the operations of our courts. Likewise, included in these challenges, of course, is the fact that video conferencing before March 2020, before the onslaught of the COVID-19 pandemic, was actually not widely used. In fact, in the Philippines, we only pilot tested it in December of 2019. And it was considered actually an equipment-driven kind of technology. It was not considered as an application-driven technology or application at that time. But as it turned out, within the following months, after the hard lockdown imposed by the government in March of 2020, people realized that this is actually more of an application-driven kind of technology. In fact, there was no need for us to supply as many IT equipments as we did in Davao City when we pilot tested this. All that was needed was to secure the platform that we can use for purposes of video conferencing. And of course, going ahead of my reaction, at present in our Philippine justice system, what we are using is the Philippine Judiciary 365 account, which has as features, one, the Outlook application, which allows emails to be exchanged by the court, between the court and the court users, and likewise what we refer to as the team application, wherein video conferencing can be conducted. Finally, with respect to I guess some of these observations and sharing given by Deputy Judge Pahladsingh, let me just discuss them a little and briefly. Of course, he mentioned that there are three kinds of scenarios when it comes to video conferencing. But for us here in the Philippines, we only more or less recognize two. One is fully remote kind of video conferencing, and the other one is partially remote. Fully remote means all are not in the courtrooms, while partially remote video conferencing involves, of course, our judges being inside their courtrooms, even if some of the parties are not and are joining online only. So likewise, let me just also mention that of course, when it comes to upholding the constitutional rights of the party, especially because of the resort to video conferencing, especially when it comes to accused persons here in the Philippines, and considering and if it's an accused who is considered as a person deprived of liberty or is detained, our Constitution, of course, has put in place a lot of guarantees. Among others is, of course, aside from the basic presumption of innocence, one is the right to be heard by counsel and of him himself, and of course to be informed of the nature and cause of the accusation being leveled against the said accused. And take note, a very important right is to have a speedy, impartial, and public trial, which our guest lecturer has emphasized to a certain extent, and in fact has discussed this matter at length. So of course, let me just state as well that as far as we are concerned, of course, necessity was the reason why we accelerated the resort to video conferencing. And the reason is simply to avoid delays, no, in the proceedings insofar as pending cases are concerned. And eventually, no, because of the noted success, no, insofar as video conferencing is concerned, not only during lockdowns, but also with respect to speeding up, no, the proceedings, no, insofar as our pending cases are concerned. These now cover not only criminal cases, not only with respect to persons deprived of liberty, but also, no, even civil cases. And take note, not only pending, but even newly filed cases at that. No? So that's how we have accepted, no, video conferencing already insofar as our Philippine justice system is concerned. I agree with what Deputy Judge Pahladsingh has mentioned, that video conferencing indeed, no, has both its benefits and disadvantages. But of course, no, as far as we are concerned, we're not only looking at this exceptional circumstance of video conferencing with respect to the use, no, or resort to video conferencing, but also because we recognize the fact that this what we refer to now as an alternative mode with respect to in-court proceedings has actually helped, no, to ensure, no, that we lessen the trials being postponed, no, insofar as parties are concerned. We're trying to avoid, no, the possibility that the cases will be delayed, no, due to postponements. No? Let me also just mention that with respect to the right to be heard, and of course, which is also a part of the right to defense, no, as mentioned or at least discussed, no, in part by our guest lecturer and also in his written article. I would like to emphasize, no, the importance of arraignment, especially in criminal cases, because whether there is video conferencing or not, the right of the accused, no, to be present actually is something that can be waived. No, in fact, the moment that there is even, no, an arraignment, no, when the accused has already been arraigned, if the accused decides not to jump bail, then trial in absentia can proceed, no, whether it's done in person, no, the proceedings in done in person, or by the remaining, no, parties to the case, or done through video conferencing. So I agree as well, no, that the right to be present, no, the right to be present in court, no, is not similar to the right to a personal appearance or attendance. However, the video conferencing platform has provided more or less a remedy, no, for these two rights, no, even if they are basically different. To my mind, this video conferencing sort of served, no, as an equalizer regarding these two fundamental rights, of the right, of course, to be present in court, and of course the right, not to personally appear, no, before court proceedings. And then of course with respect to the right to a public hearing, and of course video conferencing, when you discuss when you talk about transparency, no, the right to a public hearing, and of course privacy, the right to privacy, protecting, no, personal data and even the proceedings themselves, no. One way or the other, indeed there is there are measures, no, that need to be put in place, no, especially in the area of privacy. In the scheme of things, with respect to our court systems here in the Philippines, the one who records, no, the court proceedings is only the judge actually, no, or the court. And of course, access to these recordings cannot just be extended, no, depending on certain circumstances, as may be allowed under our guidelines. I have to say, no, that and to share with our lecturer and to everyone else that it did not take the Supreme Court very long to come up with guidelines in the conduct of video conferencing. In fact, we only resorted to it in May, and then fully, no, in June and July. And then in 6 months' time, we already have guidelines, no, as promulgated by the Supreme Court, no, to conduct of video conferencing hearings. And we're not yet done insofar as the guidelines are concerned, because this is now being reviewed. This is now the subject, no. This is now the subject of amendments, the possible amendments to further enhance the use of video conferencing. While this is an alternative mode, again, it's here to stay actually. And I think I share the same observation of Deputy Judge Pahladsingh, that I think we cannot do away with video conferencing, whether during exceptional circumstances or during exceptional times, or even during normal times, because we saw already what video conferencing can do with respect to our court proceedings, and of course, with respect to the dispensation of justice. So again, when it comes to constitutional rights, when it comes to the protection of the right to public hearing and the right to the protection of personal data, among others, I believe that this is substantially recognized and, of course, protected at all times, not only during the conduct of our proceedings pursuant to our guidelines, but also is guaranteed, no less by our Supreme Court. That's the reason why we are looking into further enhancing and strengthening this particular video conferencing platform. So again, remedies are available, even if judgment, for example, is rendered through video conferencing, because if a party is convicted in through video conferencing and not through personal appearance, as may be allowed by the court, the rights to appeal, among others, or to move for reconsideration of this particular judgment is not deprived of this part of the accused. So some of the conclusions of Judge Pahladsingh, of course, with respect to guaranteeing the right to effective remedies and the right to a fair trial, I think, as I mentioned earlier, video conferencing actually mirrors in-court proceedings. So that's why substantially this has been complied with. And the Supreme Court is very careful, our Philippine Supreme Court is very careful to see to it that we uphold all of these constitutional rights. And in fact, I'm happy to note that, of course, I may be wrong later on, but there is no challenge regarding this resort to video conferencing in every stage of our court proceedings and trial. Likewise, with respect to the technology involved, yes, indeed, there are choices, many choices insofar as video conferencing is concerned. The Philippine Supreme Court decided to use Microsoft, in this particular, insofar as our proceedings are concerned. We know that, of course, these are not owned by the judiciary, so we have to rely heavily on their system of safekeeping, many of our proceedings. But I trust that this is something that we can work out further, insofar as our provider is concerned. And then indeed, it is not a new tool, but now it is something that all of us should now be familiar with, because as I mentioned earlier, video conferencing is even if it's an alternative mode in court proceedings, is something that we'll have to embrace as part of our judicial proceedings at this point in time. And to be honest about it, without video conferencing, I think we could have been at a worse situation prior to the pandemic and during the height of the pandemic and the lockdown. And then with respect to mastering video conferencing, there is no argument regarding that one. Of course, not all can become familiar and would be able to really maximize the use of it and fully understand it. But what is important, it is something that is made available in order to ensure that the efficient administration of justice is always promoted. So I guess let me just end by coming out with my own summary. So generally, the positive review about video conferencing is not surprising. So judiciaries all over the world witness and experience how it aided immensely in the efficient administration of justice. To me, any reservation about video conferencing is outweighed by the benefits derived from it. After all, video conferencing established a much-needed visual connectivity among the principal actors or stakeholders in the justice sector between the court and its users. As it turned out, video conferencing single-handedly provided a platform to meet the challenges faced by our legal procedures, assure the continued functioning of our court systems, the upholding of the rule of law, and the protection of basic human rights. And while we saw the worst brought about by the COVID-19 pandemic, almost putting the entire community of nations on its knees, never seen before in our lifetime, video conferencing showed that we can rise above serious global adversities and difficulties. So with that, thank you, and I am truly grateful for this opportunity to give this reaction to the lecture of our guest lecturer, Deputy Judge Aniel Pahladsingh. Maraming salamat po at mabuhay po kayong lahat.
Thank you, sir. Dean Manuel Icasiano Diokno, the virtual floor is yours, Dean.
Chancellor of the Philippine Judicial Academy, Justice Mariano del Castillo, to the Court Administrator, Raul B. Villanueva, to our guest and main speaker, Deputy Judge Aniel Pahladsingh, to the Dean of the UP College of Law, Professor Edgardo Carlo L. Bistan, the Director of the Institute for Administration of Justice, Emerson Banez, of course, to my good friend, our moderator, Attorney Mabel, all of the members of the bench, the bar and the academe, and honored guests. I truly would like to thank Judge Pahladsingh for his wonderful presentation, because I think it brings a fresh and important perspective to video conferencing that hasn't really been part of the conversation of the Philippine legal community when it comes to this subject matter. While his Honor's observations are based primarily on the European Convention on Human Rights and the EU Charter, I think they would apply as well to states like the Philippines, who have ratified the International Covenant on Civil and Political Rights and other international human rights instruments. In fact, I fully agree with Judge Pahladsing's observation, and I quote, that the use of video conferencing in place of face-to-face hearings raise issues of compatibility with key fundamental rights. And I'm very happy that he has brought this into the conversation. Because when we think about it, the right, for example, to be personally and physically present in the courtroom in a criminal trial is really a most fundamental right that we have, before the pandemic anyway, had accepted as a given. Of course, under international law, the right to an effective remedy, and also under national law, a right to be heard in court, to examine witnesses and confront them, to present evidence, the right to a fair trial. All of these are part and parcel of the Bill of Rights of our Constitution that's guaranteed to every single one of us. I have to say that I find the observations of Judge Pahladsingh so apt, especially in a country like ours. He said in his paper, and I quote, "Such technology, in fact, requires several preconditions to be put in place, namely the ability of both the administration of justice and the lawyers to use the tools and the capacity and stability of the wideband to sustain the stream of information." And I believe these pre-requirements really cannot be taken for granted, especially in our situation in our country, where not all the courts are internet ready, where many of our witnesses and litigants belong to marginalized sectors of our community, where even the internet is seen widely perceived to be very slow and has lots of interconnectivity issues, which I think must be addressed as well if we are to make video conferencing really effective. But there is a question, however, that I find to be very important given the presentation of our guest speaker in relation to our own guidelines on video conferencing. And here again, I'd like to quote from Judge Pahladsingh's paper. He says, is exercising the right to examine witnesses or to be assisted by an interpreter or even to defend oneself possible without a physical presence in court, a requirement imposed by the exceptional measures to combat the coronavirus. I think at this juncture, it's important to note that our Supreme Court's guidelines on video conferencing are not really designed to be an emergency measure per se. In other words, they were issued not only for purposes of a temporary measure under the pandemic, because if you look at the whereas clause of the guidelines, it says, I quote, whereas the Supreme Court issued Memorandum Order number 40-220 dated May 29, 2020, creating the Special Committee on Virtual Hearings and Electronic Testimony, tasked among other matters to propose guidelines for the conduct of video conferencing, which shall be applicable even after the current public health emergency ceases. And the text of the guidelines does not provide any temporary or time limitation as far as the applicability of those guidelines are concerned. And which is, to me, raises a fundamental question that must, I think, be discussed by the Philippine legal community. Because when we speak of the right to be physically present, and here I'm limiting my comments only to a criminal trial, I think that that is a fundamental part of a fair trial. And when we speak of video conferencing, basically when a video conference is held, the accused is basically waiving his or her right to be physically present during the trial. I note from the court's guidelines that under the first paragraph on policy, that the consent of the accused appears to be required. But the remaining provisions, when I looked at the remaining provisions, it's not all that clear whether a court may grant a motion for the conduct of video conferencing, even if the accused does not consent. And I think that is where the issue of human rights, basic rights, may come into play. No problem if the accused consents, but if he insists on his right to be physically present during a criminal trial, and the court nonetheless requires a video conference trial, there may be some issues that would have to be resolved at some point by the court. Which brings me to a point that I think is perhaps, if I may be allowed to make some suggestions, that perhaps before, in a criminal case, any video conferencing is required by a court, that it must be made clear to the accused that is they have a right to demand being physically present in the court, and that if they agree to a video conference, that is in effect a waiver of such right. And it should be treated in the same way that other similar waivers are seen by the court, meaning that it must be free and informed consent, both on the part of the accused and on the part of the counsel. Aside from that, I believe it might be better to have some regulations that would require that no kind of pressure could be exerted or no incentives could be provided to convince or persuade an accused to agree, that it should be clearly a decision that they will be making that is intelligently, voluntarily, and knowingly made. I must say, however, that there are so many advantages to video conferencing, especially in civil administrative cases, even in terms of cases involving the different writs. I did litigate during the lockdown a writ of habeas corpus case, all by video conferencing, and it was very successful because the facts were really not an issue. The issues were largely legal in nature, so it was very convenient for the counsels and even the court to hold the hearings virtually. And we were able to finish that litigation very quickly, and it came to a very good resolution. While there are a lot of advantages to video conferencing, which I believe really are addressed by what we've done in the country by allowing it, at the same time, I take this opportunity and would like to thank Judge Pahladsingh for reminding us that these mechanisms must always be consistent with our basic constitutional rights. Thank you. Good afternoon.
Thank you very much, Dean Diokno. If we have questions on the from the floor, from the participants, you can ask your questions now. I'd like to recognize, let's all recognize please, Professor Elizabeth Pangalangan, the Director of our Institute for Human Rights. You have questions? Let me read then first the questions from the chat box. Given this is addressed to any one of our guests. Given the advent of video conferencing, how can the court scrutinize and align the responses of both parties given the fact that body language is eliminated? Who'd like to answer the question? Let me repeat. Given the advent of video conferencing, how can the court scrutinize and align the responses of both parties given the fact that body language is eliminated? Who'd like to answer the question?
Bill.
Court Administrator? Yes, please,
Yeah.
sir.
Anyway, first is I think it's very clear in our guidelines that we recognize the fact that the demeanor of the parties, especially vital witnesses, is something that we have to also look into. If it's really material, then the parties, the concerned party, can actually move that instead of video conferencing, then that's a remedy. Then they would like to ask that the witness who will be testifying should be allowed to instead testify in court or in person. Let me just be clarified. Let me clarify as well. I keep on saying that this is an alternative mode. So much so that when our situation is good, especially if it's under alert level 1, for example, our courts are fully operational, which means that what priority is now can be given to in-court proceedings. So I guess that's the time that the parties can actually move for the witness, that party to appear in person so that the demeanor can be observed. It's also stated there in the guidelines that when it's necessary, then and especially if it's one that the party is requesting, the other party is requesting, then in-person hearings can be conducted. But taking into account, of course, any possible delay, if this such insistence, especially if it's not, it does not coincide with the calendar or schedule of either the court or the parties, then the judge should see to it that you give to my mind as a former judge. So I'm saying this as a former judge. You give more premium to see to it that no delay, no unnecessary delay takes place insofar as the trial is concerned. By the way, Mabel, may I just greet also, nakalimutan ko lang, narinig ko lang kanina na present in today's event, Judge Raul Pangalangan, whom I got to see during the time that he was still an incumbent judge of the International Criminal Court. Good afternoon po sa inyo. Maraming salamat.
Dr. Villanueva. Dean Vistan, you have a question? There's the mic, Dean.
Yes, just to also respond, having attended and even presided proceedings involving video conference hearings, the premise of the question may actually be questioned in the sense that we assume body language cannot be discerned if you are in a video conference hearing. Sometimes I think people are more candid and more comfortable when they are in a video conference setting, and their body language shows more reactions or are more genuine, in my opinion. And I also noticed that many of the things we've raised, many of the issues we think of because we're lawyers. We know about the right to confront the witness face to face, the right to be present in court. These are concepts that we learn and are ingrained in our minds. But when I see non-lawyers participating in proceedings, they don't care. I think they are genuine. They are what you expect them to be, conducting themselves in the way you expect them to conduct themselves wherever they are, whether they're in person or in a video conference hearing. So maybe as we develop our principles, our rules about video conference hearings, we should also take into account not only the legal dimension, but also how non-lawyers, how ordinary people, how anyone would consider or would react to being in this modality, in this kind of setting. I do have a question for Judge Pahladsingh, because I noticed that the rulings you mentioned were always premised. One of the conditions was that these are exceptional times. So that is an important aspect of many of the rulings allowing video conference hearings. Do you expect this to change for more normal times, if we may say so?
Well, first, I will react on the last question. It's an interesting question what the legislators will do in different member states. If I have a look just to the Dutch situation, I think we will need a permanent solution. And it's also a discussion which we have nowadays in our parliament regarding to the question that we do need a permanent solution. We need permanent legislation for this exception. And I think in the future it will not be an exception, but it will be one of the possibilities to have, instead of a hearing, there's also the possibility for a video conference hearing. And I do believe that we will use it more and more in civil law cases, or probably in different administrative law cases, in which probably the facts are clear, the statements are clear, and the cases can be done in a video conference hearing system. Then regarding to the question which was asked also about the body language, I do believe that it's an important aspect at a hearing. It's different if you compare it in a video conference hearing than in a physical hearing, where you can have a close, or where you can have a full eye on the litigants and how they act. And you can take that as a judge into your consideration. So yeah, that is a different aspect. But I do believe that still in a video conference hearing, it is possible, when you can see the litigants, to see how they are moving, to see what they're doing, to have a close look in their eyes, to see how they're moving. So body language can also play a role, maybe a limited role, but there's a role still in video conference hearings regarding to body language.
Yeah, that is yours already. Judge Aniel, Dean Vistan, may we please request you to occupy the 2 chairs so you can be viewed also virtually? Yes, please. Thank you. Okay, that first question was from Solomon Karinan. Okay, let me read the next question. In case of getting the testimony of a witness who is imprisoned in another country, is court hearing via video conferencing possible? In case of getting the testimony of a witness who is imprisoned in another country, is court hearing via video conferencing possible? Yes, Judge. I'd like to speak.
Well, I did it once. We had a person who was detained in Belgium, which is a neighboring country of the Netherlands. So we had to arrange, of course, a video conference hearing, and we had to be aware that there was a line and that there was a connection which was working. So before the court hearing itself, it took a lot of time, of course, between our court staff and the staff of the prison in Belgium to get the information. For example, we in the Netherlands work with Skype for business as a tool, and in Belgium they don't have that. So they work there with a Zoom link. So that takes more time in the preparation to see if Zoom is working in our courtrooms. So we tested that, and I have to say that it worked in practice. So if there is a line and it can be guaranteed, of course, that the prisoner or the accused can be free and open, you know, to talk with the judges. So there's not nobody before him or behind him, and we have a close look from the camera, and we can receive the information. Then also in transnational court cases, it is possible, in our view at least, to do a video conference hearing.
Thank you, Judge Aniel. Court Administrator Villanueva, Dean Diokno, would you like to add to that?
Briefly lang, Mabel, I think the situation actually pertains more to remote video conferencing abroad. So meaning that the witness is abroad, so we need the testimony. So we have guidelines regarding that one. Of course, we are meeting challenges insofar as allowing the conduct of video conferencing in our Philippine embassies and consulates, because sometimes there is this requirement of a mutual consent on the part of the host country. So that is something that I think we have to further enhance on. But definitely we have a guideline regarding that one.
Thank you, Court Administrator Villanueva. The guidelines are available at the Supreme Court website. That's sc.judiciary.gov.ph. They have a very good collection of all the issuances there. Okay, let me read the next question. How can human rights protect us to live real lives? That's from Noran Esmail. Judge Aniel, would you like to go first? How can human rights protect us to live real lives?
It's a broad question, of course. I do believe that fundamental rights, human rights, should work for the people, for the persons. So in general, I would say yes, they should protect, of course, individuals. And I do believe that if we're talking more specifically about video conference hearings and the fundamental rights which are at stake, I think we have seen also with the interveners that most of the fundamental rights are respected and it's working for the person. So I would give this as a general answer back.
Michelle, Court Administrator.
Tell muna, si Dean muna.
Dean, naka-mute po yata kayo. Please turn on your microphone.
I think that human rights provide us with the ultimate protection when it comes to our right to life, a right to dignity, and a right to develop. And that is where perhaps sometimes people have a misconception about human rights. They think it's some abstract concept that is up in the air, when actually, when we speak of our very most basic right to be alive, not to be killed, our right to live with dignity and to develop to our full potential, as well as improving the quality of life of collectively as a people. That's really what human rights is all about. Thank you.
Thank you, Dean. Okay, let me read a note from Ma'am Giselle Isidro Dilag to add to Dean Chell's observation and comment. In one flag case, we recently argued the superiority of the right of the accused to confront the witness in person in view of the vagueness of the rules when it comes to situations where the accused does not consent to a video conferencing presentation of evidence. We had to use foreign jurisprudence on the importance of the confrontation clause in the Constitution. Maybe there should be additional policy statements from the Supreme Court on how to balance interests of the parties, especially in criminal cases, since our jurisprudence only discuss video conferencing for minor witnesses, or is this something already being deliberated by the committee? A suggestion from her also. I also agree with the statement that in terms of technological changes, there should be multi-level approach in upholding human rights in this digital age. Suggestion to the judiciary: access to justice may be democratized by creating remote hearing centers, probably established at IBP officers or city legal offices, that are sufficiently equipped to accommodate witnesses who may be located in remote and underserved areas infrastructure-wise. Challenge would be budget and infrastructure reliability, but that would be a big leap towards forwarding the cost for access to justice. Court ad.
I completely agree, no? I completely agree with the observation, no, that we should be more accessible in so far as making, no, video conferencing as available, no, as possible, no, to all court users. We'll take into account, no, the suggestion to come up with the video conferencing centers, no, but at the end of the day, the application, no, welcomes everyone actually, no, so long as you have the email which we can use to notify you and to include you, no, in that video conferencing hearing, then you can actually participate, no, and join, no, in that video conferencing hearing. But of course, realizing that not all, no, not maybe all has that facility, no, with respect to even an email, no, account, or even a smartphone, or even not necessarily a smartphone, but the equipments or IT equipments in order to join, video conferencing hearings. That is something perhaps that we will have to initially rely on with respect to the counsels, no, who are appearing on behalf of all of these parties. But of course, if they're not represented by counsel, then that's another thing, no, altogether. So I guess that's it, no, that to be honest about it, regarding that matter about what if there is refusal, no, on the part of a litigant, no, a party or a witness, so not to appear via video conferencing hearing, it is respected, just like any the right, no, which the court not is really, no, very conscious about. We respect, no, the preference, no, of parties. But however, I keep on emphasizing the fact that this should not be at the expense, no, of trying to delay, no, the court proceedings. When if the party wants to really appear in person or in court, then that party should really make himself or herself available, and not just say that I want an in-person hearing and then not make himself available. No, then definitely the court will have to come up with measures, no, regarding that one. So that's it, no. Thank you.
That usually appears alone on screen. How can we remedy the same? It's not addressed to anyone, so anybody can answer this question. Let me repeat. The process of identification of the accused in criminal trials has become unreliable, considering that the accused usually appears alone on screen. How can we remedy the same? Any suggestions from our speakers? Yes, Dean Vistan.
I think, as I understand the question, and just to give Judge Aniel the context. So, if it was an in-person hearing, a witness can be asked to identify the accused as if the witness was an eyewitness to what happened. Let's say among this crowd. So he has choices as to who he can point. But in a video conference, there's no crowd. You can identify the lawyer, and there's only one accused there. You know the victim. So by process of elimination, the witness will necessarily identify the accused, because he's the only one there who he doesn't know, who doesn't look like a lawyer and who doesn't look like the victim. So because there's no, I wouldn't say lineup, but in a court hearing here, litigants are in one room as they wait for their case to be called. So that's the context. I hope I understood the question correctly. So in a video conference hearing, the accused is readily identified because there's no one else there who could be the choice, who could be a realistic choice of the witness.
I think here already we see a different approach in practice because we don't have that in the Netherlands. So for me it's of course difficult then to see or to visibly see what's happening then. But I do believe, of course, that that is a disadvantage for that person. But still, I think that the court is, for example, cross-examining the person. What's your name, where you're born, your nationality, the date of birth. That's something which is done, of course, normally also in a criminal procedure. So if that is done, I would say that in a video conference hearing you have done everything what's available for you as a court.
Thank you, Judge Aniel. Maybe the court administrator and Attorney Chell can also chime in if there are ideas about that question.
Okay.
Idin muna.
Mauna na ako sa inyo,
Go
Attorney
ahead.
Raul.
Sige po, sige po.
Well, as a litigator, I don't think I would ever agree to a video conferencing, the taking of testimony of an eyewitness by video conferencing. In the first place, because generally even one positive identification could already result in a conviction. And since what's at stake is the liberty of the accused, if it's a major crime for possibly the rest of his or her life, I would really want to confront that witness face to face in court. Now, if ever I have no choice but to do it by video conference, then I would have to vigorously cross-examine the witness. And part of my cross-examination would probably entail bringing out the fact that he really had no choice in terms of making that identification. The other aspects of my cross-examination would probably have to do with the physical and psychological factors that gave rise to his identification in the first place prior to his appearing in court, when he gave a statement or she gave a statement to the police and so on. So those would revolve around the ability to see the features of the assailant, the fact that he or she only had a few seconds to witness the incident, and lack of prior training in terms of being involved in that kind of observation, distance, illumination, and other factors that could really affect the positive so-called nature of the identification. But I do believe the question does raise issues about the confrontation clause in criminal cases when we speak of video conferencing. Thank you.
Well, briefly lang. Of course, to me, it depends. No, sometimes there's a stipulation already on the identity of the accused, during pre-trial. So there's no issue regarding that one. Then, to my mind, there is no need to belabor so much on that point to try to confuse witnesses if the identity is already stipulated on by the parties. But if it's not stipulated on and the identity is one issue being raised as a matter of, as a defense, then definitely the court will accordingly have to adjust regarding this situation during when the accused has to be pointed out by the witness. If in-person hearing is required, then so be it. But if in-person hearing is not possible, then other resort, especially if the accused is detained, then other accused or detainees may be considered for purposes of trying to make sure that the witness can actually identify. But my point is, it depends, and then we will always respect the need, if the issue is about the identity of the accused, to always make sure that the accused will have that opportunity to always be protected insofar as him just being singled out.
Thank you, Court Administrator Villanueva. We have a question from the floor. Yes, ma'am, please identify yourself. Thank you.
Good afternoon. I am Mary Orr from the Law Center as well. My question is, the court is always a space that where power relations are present. So I don't know how it is in the Netherlands, but everybody moves to the whims of the judge, or to what the judge would like in the Philippines. So how do you think video conferencing has affected the dynamic among the judge and the litigants? Has it strengthened the participation of the litigant? That's for all of our speakers today. Thank you.
Well, I think that if I can start with answering that interesting question, is of course that the dynamic in a video conference hearing is different than in a courtroom. First of all, you see each other in a courtroom. As a litigant, you have more time to express yourself. You can have that body language aspect. In a video conference hearing, my experience is that lawyers should be more punctual in their pleading. They have to make their point. It should be really sharp and precise. So long statements are not working, or at least are not working effectively, I think. From a judge perspective, it's asking more concentration from our side to listen to the stories, to the pleadings, and especially when you have a long day or a day with a lot of hearings, it takes more energy and more concentration from the judge's side. So also in the preparation, I think it's different to be present in a court hearing or to be present in a video conference hearing. And still, although I have to admit that the technical devices in the Netherlands are great, it's working almost perfect, I have to say. And even if there's a hiccup, we always have technical assistants which we can call, IT persons who are really directly there. And if there's something, a delay or anything, it can be done in 10-15 minutes maximum. But that's also an aspect that a day can be long because of technical hiccups, which can also be part, of course, from one of the litigants who is, of course, having problems with their IT facilities. But still, in general, I would say it's working in a good way. So, but it's affecting, of course, the element of the day from a video conference hearing perspective.
Professor Pangalangan, you have a question? Paon, Ariel.
Thank you for your talk, Judge. I was wondering that the right of the accused to be promptly informed of the offense against him or her will require interpretation, let's say, of the hearing, no? And this includes getting regional interpreters, for instance, and I think this is one of the advantages of video conferencing, that the witness or the accused, wherever these parties may be, can easily get a regional interpreter, no? In contrast to being, let's say, in the city. Okay, but I wonder how the courts in the Netherlands have adjusted to the availability of sign language interpretation. Because I think that perhaps those who need sign language will be disadvantaged if there is merely remote video interpretation. So do your rules address this problem already?
We already have in our court procedure rules that if somebody is unable to speak and to understand the Dutch language, which is the official language in our court procedures, that the court will try to arrange an interpreter. And in the Netherlands, we have lists of interpreters related to several languages. And we have, I think, 180 nationalities in the Netherlands. And most of the languages spoken in these states are covered by interpreters in the Netherlands. So what is done normally is that, of course, it's also communicated with the lawyer of the accused, if the person is able to communicate in Dutch or not. And the question is then asked if an interpreter is needed. If it's needed, then it's arranged by the court. And mostly we don't have problems in getting interpreters then for those procedures. So because we already had these provisions before the COVID-19 pandemic. Okay. Yeah. Yeah.
Do you have something to add? None. Okay, let me proceed to the next question. What are the disadvantages if the video conference hearings are used more frequently and not just on exceptional circumstances? That's from Kidwelin Vic Bonsato. What are the disadvantages if the video conference hearings are used more frequently and not just on exceptional circumstances?
Well, I have to say, if I look at the practice of the last months in the Netherlands, we are almost ready, or almost going back to normal. So most of the cases now are already been part of the old system. So we have public hearings in most of the cases. So it's only in cases in which we think this is suitable for a video conference hearing because the facts are not clear and we can do it in that way, or that we get a message from a lawyer or a litigant that that person is ill or that person has COVID. And then we are able to arrange a video conference link, and it will be then a hybrid hearing in which everybody is there in the court hearing room, and only the party who is ill or the lawyer who is ill or has COVID will be connected with the video link and can participate in the court hearing where all the other parties are physically attending the hearing. So this is at this moment our practice in the Netherlands. We're almost back to the old system.
Thank you. Is it possible, anonymous. Is it possible for the courts, or at least partner with some agencies like this DICT, to provide internet facilities or room or infrastructures for pauper litigants to go and have access for video conferencing? I think that one is addressed to Court Administrator Villanueva.
Well, ideally, yes. I think there's nothing wrong in partnering with, among others, the DICT with respect to internet connectivity. However, internet connectivity is one thing, and the other thing is, of course, the party being able to always be extended or given proper counsel. So, to my mind, what is more important also, or at least what should also be considered, is that counsel is always with the client, wherever they may be, whether proper litigant or not, so long as the counsel is always available for the party to be able to consult with. So yun lang siguro, to me, that's more important. I know that we need connectivity, but essentially, pardon me for saying this, the things that we receive, as perhaps some challenges regarding video conferencing, maybe more related, not to the lack of access, principally, but of course to some perhaps norms, that people got used to, which is more related to in-court or in-person hearings. Connectivity, yes, maybe, but if there is a counsel, there's a lawyer representing that particular accused, we expect that counsel can, in a way, afford that connectivity, because he himself or herself has to appear in court, if done through online. So that's what I'm trying to more or less just give by way of observation. I know in fact, if connectivity is cut, no, there is no, in the guidelines even provide for that we stop, no, the video conferencing and just, if necessary, proceed to in-person, no, proceedings.
Thank you, Court Ad Villanueva. Professor Tay, you have a question.
Yeah, I don't have a position on this, so I'm genuinely curious about what you think, Deputy Judge Pahladsingh, but also for Court Ad, Raul, and Dean Shell. If we were to mainstream video conferencing as part of trials or court hearings, then it essentially obliterates territorial jurisdiction, as it were, meaning courts can actually hear cases beyond a particular territory. So I'm not sure how jurisdiction is defined in the Netherlands, but in the Philippines, for example, courts have a particular territory over which some of their writs or orders will be effective. So is that a good thing or a bad thing? I mean, in your opinion, I'm genuinely curious. I don't have a position on this. I just want to know.
Hello, classmate. May I just be clear? We're not abandoning, no, insofar as the jurisdictional coverage, no, of courts are concerned when it comes to video conferencing hearings. In fact, we're very careful, no, in allowing, for example, video conferencing in some instances outside of the courtroom, only when it's really necessary. No? But definitely, jurisdiction of the courts will always be enforced, no? And definitely we will uphold, no, the jurisdiction of all courts. It just so happened that sometimes we have to allow, video conferencing being conducted where parties may be at a different location, not inside the courtroom. But that doesn't lose the feature of jurisdiction, because the judge, no, should always be, because that's a general rule, should always be in the courtroom if conducting a video conferencing hearings. No, so I guess that's how I would address it. No, Ted. Thank you.
Thank you. Let me read the next question. How can technology...
I think Judge Aniel would like to.
Well, I think I agree with the answer which is given. I think we should respect, of course, the territory restrictions. We also have that in the Netherlands. But we see live streamings coming now from our Supreme Courts. And that's, of course, in general, the public can follow these hearings. And that's a positive aspect if we look at transparency of the judiciary. And also European Court on Human Rights is doing more and more live streaming in the Grand Chamber hearings, which they are doing. Also, to inform the public and to give more transparency. So I think that's a positive step regarding to transparency.
Okay. How can technological illiteracy and bad internet, especially in the Philippines, be addressed? Court Ad.
Okay, can you just repeat it? Sorry, Mabel. Can you repeat it again, please?
How can technological illiteracy and bad internet, especially in the Philippines, be addressed?
Oh. Parties do not file cases on the, my belief, no? Cases are filed because there is a right of action, no, on the part of any party, no, to do so. Doesn't choose the status in life, no? Just so happen that person has a cause of action, and if unfortunately that person is marginalized, access to the court is not being deprived, no, to that kind of a person. That's what I would like to emphasize. Video conferencing, it was not intended to favor those who can afford the technology. In fact, it is intended to cover all kinds of litigants. No? So to my mind, we are doing everything to make this technology challenge, no, litigants to still avail, no, of if they cannot attend in person, then resort to video conferencing is necessary, that these facilities are available to them. So that is the general, no, view of the courts, no, of our courts, and even of the Supreme Court. Access to justice is something that we will always extend, no, to everyone.
And access to justice in relation to video conferencing. how do we reconcile that with high inequity in access to internet and technology in the country, especially in rural areas? Are there steps taken by the judiciary or IBP to address these issues? I think that.
Let me just siguro briefly answer that.
Yes.
No? You know, the Chief Justice Alexander Gesmundo is looking into this. You know, the kind of connectivity that we have is considered either of two One is fiber optics and the other one is another setup. Fiber optics has more coverage, and in fact, that's one thing that we're trying to consider right now. No, when we provide connectivity for our courts, that this will be accessed by all, no matter how remote the court may be located or the litigants may be located. So in other words, we're going towards that already, trying to provide our courts the ability to make available access or connectivity to our systems. So that's one thing that we are doing right now, and the Chief Justice in his 5-year strategic plan actually includes as one of the major push insofar as our justice system is concerned is access and of course innovation with respect to our proceedings. And of course just to emphasize that Chief Justice and the entire embank right now, they want a technically driven court system in the country within the next 5 years.
Dean Vistan, yes, please.
Thank you. One thing that can also help is also another positive move of the Supreme Court, which was to require all law schools to have clinical legal education programs. Through that requirement, many law schools now across all the provinces in all areas could have legal clinics that could then be the venue where litigants, the parties, can attend hearings conducted through video conference. So that's another thing that will help in the meantime as we build up our technological infrastructure.
Okay, this kind of different, hard to answer question. The Philippines experiences different problems, including war and massacre. How can we give it justice for our country? Would like to answer that? Yes, it's a very general one. Okay, let's proceed to the next. And let's stick to our topic. A litigant requested that a video conference hearing be conducted in the embassy. However, the German consulate denied the request that stated that VCH should be conducted in the German domestic courts or public prosecutor's office with the assistance of the DFA. If that is so, what would be the legal implication of the testimony taken in the German domestic courts vis-a-vis the Philippine court that VCH should be conducted in the embassy? Court
Well, if I may,
Administrator.
the basic premise why we allow the conduct of remote video conferencing abroad in our Philippine consulates and embassies is, this matter about jurisdiction. Because our Philippine consulates and embassies are considered as part of Philippine territory. Of course, if the hearing is done outside of our Philippine territory and then it's done, for example, in a German domestic court, then in effect, it goes outside of our jurisdiction. We'll look into that. We're not closing our doors, so to speak, regarding these kinds of possibilities. But in the meantime, what we're trying to do is really make sure that I'm sorry for that. Sorry. Anyway, what we would like to do is to make sure that this works. This setup that we are trying to that we have put in place regarding video conferencing remotely abroad will work. If not, then we have other ways of getting the testimony of witnesses who are abroad, and of course deposition taking is one of them. It's still there that we can resort to in the meantime that we are able to come up with a policy regarding the situation mentioned in that question. Thank you.
Thank you, Court Ad Villanueva. For lack of time, let me just read the last question. For witnesses appearing in court, from Judge Pia Bersamin Emboscado. For witnesses appearing in court during the pandemic, will it not be hard for the judges to observe their facial expression as they cannot take off their mask in the courtroom?
before the others answer, I hope with your permission, Dean Chel, no, and Deputy Judge Pahladsingh, since it's a question coming from a judge, may I just state, no, for the record, that we have to observe, no, all health protocols, no, in with respect to in-court proceedings. Sometimes, if there is a need, no, to take off the mask, then that can be allowed, no, even for a few seconds, no, or for a few minutes, if there is risk, no, there's a health risk. But definitely, we don't want to use as an excuse, no, the non-removal of the mask, no, in order to serve an injustice, no, to anyone who may be prejudiced, no, by that kind of policy. We do not have that kind of a policy. When it's in-court proceedings, then definitely there's a need to take it off. Observing all health protocols, then it should be allowed. If the witness is sick and still is allowed to attend court hearings, there is a reason to cancel it in the meantime, so as to avoid being infected with the virus or any kind of illness.
Thank you very much. So with that last question and the answer of Court Administrator Villanueva, we end the open forum. With the permission of the body, with the permission of Judge Aniel, if we can excuse Court Administrator Villanueva, it's the death anniversary of his father. Court Ad, maraming salamat po for joining us this afternoon. You are excused, sir.
Okay, thank you. Maraming salamat. Permission to leave.
Thank you very much. Okay. Okay. Let me call on Dean Bistan and our indefatigable director, Prof. Emmer, to hand our token to Judge Aniel Pahladsingh. She can stay here, sir. There's the camera.
Okay.
Kuha si College of Law. Thank you, sir. Okay. To formally close the session, may I please call on again our indefatigable director, Prof. Emmer. Hindi ka dito, Prof. Emmer. Please welcome Professor Emerson Banyas.
Before I forget, I'd like to thank all our guests, our distinguished speakers and reactors, those who were able to join us here and online. I hope this is the first of many sessions where we can engage with the judiciary, with practitioners, where the academe can engage the practicing bar, and where theory can meet practice. Right? So I was intrigued by that earlier question about the court as a space, because when you think about it, the court is such an unnatural space, right? Everything from from that separation between the court and the gallery, the way that the judge is elevated, the way he dresses, right? Everything is there to help reinforce this procedure, which in turn is there to reinforce this very structured, very ritualistic conversation, right? Well, conversation in a language that is barely English, right? So and the space is also there to support the judge's power to control the flow of information, right? So that is the architecture of the trial court as we know it. But what is the architecture of our online spaces? It's quite different, right? Because when you think about it, we are conducting these video conferences over the public internet, right? There is no custom-built network for video conferences and proceedings, right? And so that means that the architecture of the internet is, it was originally built for scientists to share papers, right? The truth is, the people who built it did not account for privacy. It did not account for security. It did not account for, for authentication and identity. Right? That's the architecture of the internet. So there's a gap between the controlled space, right, of the physical courtroom and the floating, the floating squares in our video conferencing systems. If you ask me, who is controlling the flow of information now? It's not the guy on the rostrum. It's those boys over there, right, behind with the computers. Right? So all these difficulties notwithstanding, I hope that we continue to try, ever mindful of the limitations of the technology. Because the sooner we accept that our systems can be less than perfect, the sooner that we can move forward and have our systems be good, right? And we have to keep trying because we are still in a crisis after all, and in a crisis, sometimes that is all there is to keep trying. So thank you very much.
Okay. Maraming off. Thank you very much. So with that, we close the activity for this afternoon. Salamat po ng marami. Those virtually present, in behalf of the group here also, thank you very much. Dean Diokno, salamat. Dean, can you stay for a while, please, for photo op lang po? Everybody in this room, please face the camera for an official photo op. Kita lahat. Dinchel, tingin daw po sa camera. Thank you. Hindi ko na po i-announce, there's merienda. Please help yourself. There's refreshments.